Good morning and welcome to our fourth Building Generational Wealth webinar. It's part of the Generational Poverty Law Project, a partnership between Atlanta Legal Aid Society, the Georgia Heirs Property Law Center, and Pro Bono Partnership of Atlanta. Our goals are to utilize our joint resources to create pathways out of generational poverty for low-income families in Atlanta. And in doing that, we provide free and vital legal services to multi-generational families. We also conduct outreach and education for Metro Atlanta families living in poverty and nonprofits like you who are serving them to provide tools to help those families remain housing stable and transform underserved communities. And thanks to the Junior League of Atlanta who is helping to fund the Generational Poverty Law Project. Just a little bit about us. I'm Joanne Johnston. I'm the Georgia Heirs Property Law Center's Legal Programs Director, and with me is Gentry Mander. She is the Center's Equal Justice Works Georgia Housing Corps Fellow. Just a few seconds about the Center. So the Georgia Heirs Property Law Center's mission is to increase generational wealth, social justice, and community stability by securing and preserving property rights. We have 6 attorneys, a social worker, and 2 community advocates, as well as a network of pro bono volunteers and grassroots organizational partners. And we have our focus is in Atlanta, as well as South and Southwest Georgia. We have offices in Atlanta, Athens, Fitzgerald, and Macon. And the center specifically provides 3 buckets of work. We provide legal support for families, individuals, nonprofits, and municipalities with title audits, clearing, and remediation. We also do land loss prevention services to help slow down property and land loss and secure property assets through legal and mediation counsel and development of estate plans. And then finally, we do asset education. We educate community members and stakeholders like you about heirs property and potential impact on owners in their communities. And we educate landowners about ways to increase the value of their land.
So I'm going to talk about what happens when you die without a will. When you pass away without a will, it's called passing intestate. And when you pass intestate, your heirs are determined according to the Georgia Code. A probate judge will determine who your administrator will be. And the probate judge would also decide who might become a guardian if you have any minor children. So in intestate succession, that's how your property passes according to the code. If you pass away with a spouse and no children, your spouse inherits everything. If you pass away with a spouse and children, your spouse and children split it, with your spouse receiving no less than 1/3. If you don't have a spouse, your children just split it. If you don't have a spouse or children, it goes to your parents and then down to siblings, nieces and nephews, grandparents, aunts, uncles, etc. So the reason that passing away without a will is a problem is that, like I mentioned, your property is passing according to the code. So your property is divided equally, regardless of whether whether one heir has a greater need or an interest in the property. It also increases the risk of disputes between your family because everybody's arguing over now what to do with this shared inheritance. And then if it's inherited by more than one person, it becomes heirs property. Any questions so far?
Okay, so let's go to the next section. So what happens when you pass with a last will and testament? So we've all probably heard about last wills and testaments, but only 35% of us in this country actually have them. So a last will and testament is a legal declaration of a testator's intentions regarding the distribution of property upon death. Just a couple terms as we go through. The person making the last will and testament is the testator or testatrix, and that last will and testament only takes effect upon death, so it's not capable of transferring any property during your lifetime. So there are 4 functions of a last will and testament. Again, it allows you to give property to others upon your death. It allows you to appoint someone called an executor, a trustworthy person that will oversee your estate after you pass. It allows the testator to establish what's called a testamentary trust and appoint a trustee. That's usually done for minor children or adults who are quote-unquote incapacitated, meaning that they can't make legal and financial decisions for their own. You create a trust through the will and the trustee manages any property that are left to those minor children or adults until the minor children come to a certain age, or most likely for the incapacitated adults for life. And then lastly, it allows the testator to appoint a guardian and conservator to protect the interests of those minor children and incapacitated adults, it's the legal term for it. So some requirements for last will and testament. Anybody actually 14 years or older in the state of Georgia can make a will. To be valid, and these are very important, because Gentry and I see this all the time, where someone thinks they have a will, but it doesn't meet all of the requirements. It has to be written. Georgia does not accept, unwritten wills, verbal statements about what someone wants to happen to the property. Those aren't considered legal or enforceable. In addition to being written, it has to be freely and voluntarily signed by the testator or a disinterested person in his or her presence and at his or her direction. So if someone is not able to physically sign, but the testator is in the presence of a disinterested person who can sign for them and directs that disinterested person to sign, that's sufficient. You also have to sign it in the presence of 2 disinterested witnesses. So disinterested witnesses being folks who aren't an heir or beneficiary, or who are not going to receive something through the last will and testament. And again, it's going to transfer property upon death only. There's no particular form for a last will and testament in Georgia other than it having to be in writing and it having to have the proper signatures and witnesses, so long as it makes the intentions of the testator clear. And again, Georgia does not recognize oral and witness last wills. We get a lot of clients who will come in and say, my mom said that I was the one that was supposed to have this piece of property. And unfortunately, if it's not in writing, witnessed, and signed properly, that's not something that the law in Georgia is going to consider binding upon anyone. So it would be considered, it wouldn't be considered a will, and that's not how the property would likely be distributed unless all of the heirs happen to agree. A couple of things about what can be distributed through a last will and testament. A lot of property can. It's your home or your real estate if you are the sole owner, or what's called a tenant in common, meaning that you have a partial undivided interest that you share with another person, and that interest is passed to your heirs if you die without a will, or to your beneficiaries if you pass with a will. Vehicles, personal property, which is effectively anything you can pick up and move, and money in your bank or investment accounts are things that you can distribute through a last will and testament. Things that you can't distribute are home or real estate owned as joint tenants with rights of survivorship, and that means you own a piece of property, and the deed specifically says that you are owners as joint tenants with rights of survivorship. And what that means is, when one of the co-owners passes, that deceased interest holder's share goes to the survivor. So if you are, in most cases, it's spouses. So if one spouse passes with property as a joint tenant with rights of survivorship, the surviving spouse owns the whole property without the need for probate. Other things that a will can't distribute are life insurance policies, retirement accounts, pension plans, 401ks. Those funds and policies always ask you to name beneficiaries, and so those beneficiaries are the ones that you name and provide to the company that's handling the insurance policy or the retirement account or whatnot. Those are the beneficiaries who are going to receive those funds regardless of what the will says. The only exception is if your beneficiary says is as your estate. Joint bank accounts, so bank accounts that people own together or pay on death accounts or securities, those are going to go to the joint owner. So if you and your mother have a joint bank account together and you pass away, your mother is entitled to all of the funds in that jointly owned bank account without the need for probate. And other things that aren't transferred through the will as property that's held in a living trust. So some important terms in last wills and testaments. You hear them a lot, but not a lot of people necessarily know the legal definition. A decedent is a person who has passed away. It's usually the person who dies with a will, but it's also, when you go into probate, what you call the person who passes away with a will or without a will. An estate is all of the property that the deceased person owned at the time of his or her death. That's real property, that's personal property, which you can pick up and move, cash that can be distributed through an estate. So that's an estate. The beneficiary is the person or persons who will receive something under the will. So if I leave a last will and testament leaving my house to Gentry, Gentry is considered a beneficiary of my will because she's going to receive something from the will. Descendant is important. A descendant is a lineal descendant, so a child by birth or adoption. A lineal descendant or descendant does not include a spouse. An executor is the person in the last will and testament that you name that will oversee your affairs and your estate after you pass. We usually recommend that people name at least 2 and preferably 3 executors, because executors, if named, are not required to serve, and some will have maybe passed away before you or be unable or unwilling to serve, and then you need to have a backup to fall to. We also tell folks to talk to the people they want to have as executors beforehand so that they can make sure that that executor is able and willing to serve, because if they're not, then you would need to go and find someone else to put in your will who is willing to serve. And then the last one is the fun term per stirpes. You see it a lot in wills. It's the distribution of an estate when the beneficiary dies before the decedent. So if I leave my house to Gentry and Gentry passes away, what's going to happen is I say in my will that I give my house to Gentry per stirpes. That means if Gentry predeceases me and has children, so descendants, those descendants would receive the share that she would have received. And so some folks give out their property in their will per stirpes, especially if it's to family members. If it's to my sister, per stirpes, my sister passes before me, but she has children, those nieces and nephews receive what my sister would have received in equal shares. So this is the most important thing. Who needs a last will and testament? Most people, as I mentioned, don't like to think about what happens when they pass away. And again, 35% of Americans have last wills and testaments. So that means, if I'm doing my math in my head, 65% of Americans are passing away without a last will and testament, and that's problematic for a lot of the reasons that Gentry already mentioned. So everyone actually needs a last will and testament, even if you don't have a home, have significant, what you would consider significant monetary assets, or minor children. It's a very big misconception in this country that wills are only for the wealthy, but individuals with small and modest estates actually benefit equally or more from having a last will and testament. If you have, less property to give out, right? You want to know that the property that you're giving out through your estate is going to the people that you want and that possibly need it, rather than allowing Georgia to decide what to do for you. Low-income individuals and seniors are especially vulnerable after a relative's passing, especially if that's the primary money earner in their household. And so having that will in place will protect those seniors and other vulnerable family members. And for example, right before we started, I was sharing, I have a client who was a second wife. Her husband, she co-owned a piece of property with her husband, and her husband passed away without a will. And she, second wife, now owns the property with her 5 stepchildren. And her 5 stepchildren have to agree with her on what to do with the property. And she is actually stuck in a home that she's not able to get around much in. She's elderly and needs to move to a new home or apartment where she is accessible to her and her limited mobility. And so right now we are trying to deal with the stepchildren who are not wanting to give stepmama or dad's second wife a piece of the property. And so that's the kind of thing, even if you're a low-income individual, you do have property, and not leaving a will does have implications for you and for your family that folks should really consider before in trying to get a last will and testament. And other reasons why people need them, right? It ensures that your wishes are carried out exactly as you want them by a chosen executor that you trust, right? It allows the testator to choose someone trustworthy also to care for your minor children. You're the one who best knows what is best for your children, and you best know, your relatives and your friends, and so you're the one to make that best decision, not leaving that up to, a probate court or strangers to decide for you. It also protects the financial interests of your family, especially, as we've talked about, surviving spouses and minor children. It also, if you're doing it properly, and you're talking to your family during the process, you're asking family members, well, these are the things that I have right now that I will pass to you upon my death. I have a house. You live in another state. Do you want an interest, or do you want this house? Are you going to move back and live in this house, or can I give it to your sister that's living in Atlanta? Things like that and discussions like that make it easier for you to make decisions about who to leave your property to. Also makes it easier for, if you've had these discussions, for after you pass, your relatives, your children, to understand why you did something. You'll understand why Mama gave sister the house. It's because we talked about it. You live in another state. You said you didn't want to come back. And so it's not leaving a lot of mystery around what you decided and how you decided to do things. It also gives families time to grieve without having to argue with lawyers, although I think we're fabulous, about who gets what property or who's going to take care of the minor children. Those are things that are, losing a family member is a very difficult time, especially a spouse or a parent, and anything that you can do after you're gone to make things easier for your family, it's best to do that, even if it's not the most, exciting or fun thing to think about. These are things that are going to protect your spouse. They're going to protect your children, your other family members during the important time where they're grieving over the loss. Okay. A couple more things for those of you who have wills, or those of you who work with seniors and other homeowners and folks who do have wills. It's really good that you should look at them annually and see whether any updates need to be made. They definitely need to be made if you have a birth or death of a family member, a divorce, an illness, or changes in the community or economy. If you do, you're not married at the time your will is drafted, or you have another kid, it doesn't completely void your last will and testament, but you do need to make updates to make sure that things like a new spouse or a new child are adequately taken care of under your estate plan. This is the other important thing that I've seen folks do, is folks will think that they can make changes to their last will and testament by writing on it. And that's actually a no-no, and it will invalidate the will, and it will be as if you passed away without a will. So any changes need to be made by preparing a new will or getting a codicil to your existing will. And that just makes sure that, your relatives don't come into our office and we have to say that the will is invalid, and it's as if that person died without a will. So you can have the best of intentions, right? And want to do this planning for your family after you pass, but if you're not doing it, if you're not signing the will in the proper way, if you're not witnessing the will in the proper way, if you're going back and trying to make changes on the document yourself, you're invalidating all of your hard work and planning. So another important one, especially for folks who work with seniors and parents, and someone who has a last will and testament, and we get this question a lot, which is, where should I keep it? It should be kept in a safe and accessible place. Options are a fireproof, waterproof safe, or the little boxes they sell, your executor safety deposit box, or you can go down to the county probate court and file the original will with the probate court. Your executor needs to know where to find it. So if it's in a safe, if it's down at the probate court, they should know where they can access it if and when you pass away. And another really important thing that I don't think a lot of people realize is you should not put your last will and testament in your own bank safety deposit box because you actually need a court order to get that opened after you pass. So I think that's the end of that section. Hopefully I didn't go too fast, so we have some questions.
We do. We have a question. If someone makes a change to the document after the fact, wouldn't it invalidate just that particular section and not necessarily the entire will? You might want to repeat the question.
So the question was, if someone makes a change to the document, wouldn't it invalidate that part that was changed instead of the will? Right? And Gentry can correct me if I'm wrong, but if you write the change on the will itself, that invalidates the whole will, right? Or is it wrong?
I also
I get it confused with Florida, so I'm not sure.
So to be safe, don't write it. You can write what's called a codicil saying this section 2, this paragraph 2 that is in my original will that I am not writing on. Section 2, I am changing to XYZ. And you're going to clip the codicil, you're going to have it signed, you're going to have it witnessed and hopefully notarized just to be safe, and you can clip that codicil to the will. But actually, and that would just change paragraph 2. But actually, writing on paragraph 2 on your existing will, it's my understanding that it is invalidating. It would invalidate that, but if somebody asks that question, wants to give me their email address, I can triple check. But the best practice is to do what's called a codicil and make, paragraph 2, my original will says this, I hereby make these changes, I sign it in front of 2 witnesses, get it notarized just to be safe and sound, and then clip that to your existing will, and that is sufficient to change.
Just a safer bet.
Yeah. Anybody else have any questions? Nope. Okay.
Okay, so I'm going to discuss what happens when a loved one passes in the probate process. Probate was always kind of, it's like this thing out there, but how does it really work? So probate is the process of proving the validity of a last will and testament. That's probate, means to prove. So you're proving that it was signed by the person who purports to have signed it, that it was signed properly, etc. So probate, and then once you take the will in and begin this proving process, then the courts will appoint the personal representative, and that personal representative then will pay the estate debts and distribute the estate property. So that's the whole probate process. Before a last will and testament can transfer title or even go into effect, it needs to be probated with the court. So just having a will saying that you're entitled to some property does not mean you actually own that property. Ideally, the probate process happens as soon as possible after somebody passes away. What happens is the longer you wait, the heirs to that person may pass, and the probate process just gets more difficult getting notice to the people who are entitled to notice. The probate process is overseen at a county level. So if the decedent was a resident of Georgia, the estate needs to be probated in the county in which the decedent passed away. If the decedent was not a resident of Georgia, then the estate is probated in whichever county the decedent had an interest in property. So even if they didn't own property, they just have an interest as an heir in property, let's say in Fulton County, then you can open an estate for that person in Fulton County. You do not need a lawyer to probate. There's forms available online, and Fulton and DeKalb County have probate information centers where you can make an appointment with a volunteer attorney to get your paperwork started. Now, typically, this is for people who are starting the process in a timely manner, and it's not a very complicated, won't be a complicated probate process. So to make the best use of the information centers, you need to get on top of things. If you're a qualifying low-income family, you may be eligible to have your probate fees waived. Typically, we see them ranging from about $250 to $350 per petition. So there's kind of like two tracks. If you pass away with a will and you pass away without in terms of probating, and the terminology differs between the two. So if you pass away with a will, you have an executor, and that's the person that's named in your will. A beneficiary is the person named in the will who will receive under the terms of your will. And then letters testamentary is the document that the court gives to the executor once they've determined that the will is valid, that gives the executor the power to do the things they need to do. So, pay debt, give notice to creditors, and then distribute the property. And then on the flip side, if you pass away without a will, then your personal representative is called an administrator. And then the people who receive your property, they're called heirs. So these are the heirs that were determined according to the code, as I mentioned earlier. So You can have beneficiaries and an heir. If you pass away with a will, the people in your will, as I said, are beneficiaries, but the court gives notice to your heirs, so they might not be the same person. So in an example Joanne gave was that maybe in her will I'm a beneficiary, but I'm not an heir, and so I'm not entitled to receive notice that somebody is trying to probate Joanne's will because I'm just a beneficiary, not an heir. But oftentimes they line up. And then the document that you receive from the court giving the administrator power is called letters of administration. So this is similar to letters testamentary. It's just a different term if you pass away without a will. If you die with a will, the petition you will file is a petition to probate in either solemn or common form. The petition to probate in solemn form requires that all the heirs receive notice, and it's immediately binding on all parties upon entry of a final order from the court. That's the final order of who's been appointed to be the executor. The petition to probate in common form, you don't need to give notice to all the heirs, but heirs can raise objections or contest it for up to 4 years after the petition's been filed. So it's not as kind of a sure thing because you don't have to provide notice. There's a little more leeway for the heirs to pop up later. So the person who's supposed to petition to probate the will should be the executor. If the executor doesn't do what they're supposed to do, any interested person can file a petition for letters of administration with that will annexed. So if the executor is just kind of sleeping on the job and there's property that needs to be distributed, somebody else can step forward with a different petition and get that process moving. There's generally no time limit for probating a will, but if it's been more than 5 years since an estate was opened, or more than 5 years since an order was entered saying that no administration is necessary, then you cannot then go back and probate a will. So if somebody files a petition for no administration necessary and an order is entered, the judge says, fine, this is how we'll distribute the property. You can't then come back and say, whoops, here's a will, 5 years later and say, let's probate this will instead. You do not have to probate a will in Georgia, but somebody is obligated to at least file that will with the court so that it's there for safekeeping and for public record. So to challenge a will, you can file a caveat. The grounds for doing this would be forgery, duress, lack of capacity. This comes up when the decedent was, getting it up there in age, and maybe they didn't have all their mental faculties, and somebody was their caretaker and had extra influence over them. Was the one who was driving them to the attorney's office and sitting in the meeting with them and directing them. That's a common reason to file a caveat. But I will note that the bar for creating a will is much lower than the bar for other legal documents. So like a contract, you have to have a higher mental capacity to sign a contract than you do to draft a will. So it's a tough case to make that somebody didn't have the mental capacity to make a will. Only individuals with an interest in the estate can file a caveat. So that's why you might find a will where somebody leaves something to a person, something small to a person. Where was I going with that?
So they have no ability to object for being left out?
Right. Thanks. You also have the option to distribute property contrary to the will if everybody gets together and signs a settlement agreement. This has to be unanimous, and you do not have to get a probate court to approve it, but it's a good idea to go ahead and get their blessing so that sometime down the road somebody doesn't come back and raise a stink that you then have to fight about. If you die without a will, what you would typically file is one of two things. One is a petition for letters of administration. This is letting the probate court know that, to your knowledge, there was no will and that somebody needs to be appointed administrator. The administrator can be basically anybody, but there's a hierarchy for who the court prefers would serve in that position. Once notice has been provided to the heirs, if nobody objects, the court typically will appoint that administrator and issue those letters of administration that I mentioned earlier. Depending on the heirs, the administrator may have pretty broad powers if the heirs consent to it. Otherwise, the administrator will have to ask the court permission to do basic things like sell the property when it comes time to do so. If the heirs can unanimously agree on what they would like, and they can do a petition for an order declaring that no administration is necessary. So maybe it might even be the same thing as intestate succession. So maybe the 4 children say, yeah, we all want our quarter, but it's kind of a quicker one-step process where the judge just goes ahead and does an order declaring no administration necessary, and then it serves essentially as a deed. Or you could say, you know what, let's give everybody's share to my sister, and so you do a no administration necessary with 100% going to one of the heirs. And the reason it's a one-step process is because the administrator doesn't then have to, if you do the letters of administration route, the administrator would need to be appointed, would then need to do a deed out to all of the heirs, and then those heirs would need to deed the property to whomever they decided to consolidate ownership. And so this is kind of a one-step process. It's a good option for small and moderate estates that don't have a lot of debt. And there's no time limit for filing a petition when the decedent died without a will. Question?
We have a question about probate requirements for wills in foreign countries.
But is
Curious, what is the probate requirement for a will in a foreign country?
to probate a will from a foreign country in the United States, or to probate a?
Yeah, I'm not sure.
Well, I mean, regardless, I don't really know.
Right, yeah.
Could you repeat the question? You want to repeat the question in case I didn't hear?
Repeat the question if they didn't hear.
Oh, I'm sorry.
The question was, what are the requirements, I assume, for probating a will from a foreign country in Georgia? And so we're not familiar with those because we've never seen it. But if you want to put your email address in, we can try to point you.
I think it's for probating it in a foreign country.
Okay.
Then it would depend. If you're probating the will in a foreign country, it would depend on the requirements of that foreign country, I would imagine. So in the United States, the rules for executing a will may differ between states, but typically if it was valid the way it was executed in Florida, then it's going to be recognized as a valid will in Georgia too. So there's transferability, so I'm not sure when you go to a foreign country. Is that the only one?
That's the only one so
Okay.
far.
Let's see, appointment of personal representative. I think I kind of talked about this. So a personal representative can be either an administrator or an executor. This is the hierarchy of administrators. As I mentioned, anybody can serve as the administrator, but the court will give preference to a surviving spouse unless a divorce is pending. If there's no surviving spouse, the next preferred person to serve is somebody who's been selected unanimously by all of the heirs, by a majority of the heirs. Selected by a majority of the heirs, we like unanimously because it makes your life simpler. Any other eligible person, and then a creditor or even a county administrator can step in and serve. The job of the personal representative, whether it's the executor or the administrator, is to settle the estate as quickly as possible. The idea is not to just open an estate and leave assets floating around in there. It's not supposed to be used like a trust. So the personal representative will take an oath, and if required, post a bond. This is if there's any cash assets in an estate. They need to then, based on the amount of cash that's suspected to be in the estate, the administrator will need to go secure a bond. It's basically to ensure they behave appropriately. This requirement can be waived if all of the heirs unanimously waive that requirement. The personal representative then needs to take an inventory and see what the decedent had. They may need to file a copy of this inventory with the court. Again, that's a requirement that can be waived by the heirs if everybody agrees to it. Then they will need to publish a notice to creditors and debtors and let people have time to step forward and let the administrator know if there's any debts. Those debts then need to be paid. And then the assets can be distributed to the beneficiaries or the heirs. The other thing representatives might have to do is file returns. This is like an annual accounting of what money has come in and out of the estate. This is something else that can be waived by the heirs if they unanimously agree to it, and something that can be waived in your will if you have a will. Once the responsibilities have been completed and the personal representative demonstrates to the court that they have adequately provided notice to the creditors and debtors, paid such debts, and performed all their responsibilities, then they can then petition for a discharge. And this terminates their liability with respect to the estate and closes the estate out. Personal representatives are entitled to compensation and reimbursement of expenses unless the will says otherwise.
Do we have any questions? Well, we're at a good stopping point.
Not yet. Let's see. Nobody seems to be typing.
Okay. So no one is typing, so we will keep moving. So the next section, I think, is something that people don't know a lot about. And for folks who are working with nonprofits that work with seniors, that work with families, especially those families who are grieving, this is an important thing to know, right? You don't have to know the nitty-gritty details, but you should know kind of what the opportunity is, and then most importantly that there's a time limit for this opportunity. So it's called year support. Year support is what I call a financial protection for surviving spouses and children, minor children under the age of 18. And it's a funny term. It's a little bit amorphous and difficult to understand, but it's basically the amount of money, if not money, then real estate, personal property assets, the amount of assets from the estate, a value that is sufficient to maintain and support the surviving spouse and or the minor children for 12 months. So 12 months is a year, so that's why it's called a year support award. It can include personal property and real property, and it's actually a really good way for folks who inherit, surviving spouses, for example, who inherit property with adult children especially, should go to the court and try to get an order giving that surviving spouse the house in its entirety, okay? So, you know, even if someone passes and they don't have a large bank account, right, this is still a possibility to get other things from the estate. So usually it's the most important way that you do it is, especially if a surviving spouse and minor children are living in a house that was owned or co-owned by someone who's passed away. Year support is a great way to protect those folks who are living in the home. So it allows so in the case of real property, you know, money, they determine how much money would be needed to maintain and support those surviving spouses and children for a period of 12 years. And then the court grants them that monetary allocation. But most of the time, with low and moderate income folks, the amount that's needed to support them, surviving spouses and minor children for 12 months is going to be more than any actual cash assets that might be in the estate. So, you know, we'll focus, for those of you who are housing nonprofits or working with seniors, on how you can use this to get the house for the surviving spouse or the minor children. And if a house or other land is awarded through a year support petition, that surviving spouse and minor children receive that piece of property free of all debt except a mortgage. A mortgage is something that's always going to be there and runs with the property. So you can't use a petition for year support or year support award to escape an existing mortgage on a piece of property. But if there are past unpaid taxes, if there are credit card debt and the like, the persons receiving the year support petition, so the surviving spouse and or minor children, receive that property free of the decedent's debt, with the exception of mortgages. It also wipes out any past due property tax liens. So if the person who passed hadn't been paying property taxes, and that piece of property is awarded to the surviving spouse or children through a year support petition, then those past due property taxes are wiped out, and they may be debts of the estate, right, but they do not attach to the piece of property the spouse is receiving. So if the spouse is receiving a house with a bunch of unpaid tax debt, they're not responsible for that debt, and that debt is not a lien against the home. And this is actually something that folks are entitled to, even if there is a last will and testament. So even if you receive something in a last will and testament, a surviving spouse and or minor children can ask for a year support award, and sometimes they would receive more than they might have received under the will. It also, if a spouse is mean or vindictive and doesn't, in that deceased spouse's will, they try to cut out the wife, surviving spouse, the surviving spouse is entitled to something from that estate. So it doesn't matter that the person who passed away didn't want the spouse to receive anything. The spouse under Georgia law is entitled to year support, enough to support and maintain them for 12 months, regardless of what the will says. So when you're dealing with clients and folks, in the housing nonprofit space and seniors and families, and you know of a spouse or a parent who's passed away, it's the time, even if it's not your kind of thing, like how you're working with people, you should mention this opportunity, because there's the only opportunity and window you have to go and ask the court essentially for the house or for assets that you want to be entitled to. You have 24 months to file that petition. So if I pass away today, if I have a spouse, my spouse has 24 months to file a petition for year support, or he or she loses that benefit, right? You can also lose that benefit if before you file that petition for year support, if you're a spouse, you remarry or you pass away. So if you remarry and you haven't filed that petition for year support, you will not be entitled to any award from your former spouse's estate. Minor children, if it's not filed before they turn 18, then they lose that entitlement. Or if they pass away, then obviously that entitlement, that year support entitlement is no longer there. Again, for low-income folks, it is possible to ask the court to waive probate fees. It wouldn't, I think, petitions for year support, I think in Fulton County, cost $185 to file. There's the opportunity for low-income folks to ask the probate court to waive those fees. It might not waive the cost to do an advertisement in the newspaper if required, but it would allow, it would hopefully keep that filing fee from being the hindrance or what keeps people from going and trying to get this award. So year support is just an amazing thing that folks don't really know about. And so that's one of the things we wanted to make sure everybody knew just enough about to direct, clients, friends, family members to, resources that can help them try to get the support award. So in the petition, you don't have to put a lot of detail in, right? You can say, basically, I am petitioning for a year support award that includes the house that I'm living in, and even if you co-own the house, right? It's either the house that your deceased spouse owned or co-owned with you. You can file a year support petition and say, I want the house. I want to own the whole house. And this is important. For example, in the example that I used earlier, my client did not do this in 2 years, right? But if my client was the second wife, her husband, she co-owned the property with her husband, he passed away, and husband had 5 adult stepchildren. It's 5 adult children, right? So the client now owns the property. She owns the property with 5 adult stepchildren. If she had gone and done a petition for year support and asked for the house, if successful, she could have, through that petition and that award, received title to the entire house. and been protected and not have to 8 years down the road when she needs to move, have to go and wrangle with her stepkids about what to do. So you can say I would like the house, you can say I would like, if it's a separately owned bank account, I would like everything in the bank account, I would like all the furniture, I would like the car. You know, a lot of people will just list everything, right? Just list everything that your spouse owned and the petition for year support to see if they get it. The petition, you actually don't have to say how much you would need, how much property or cash you need to support yourself or support these minor kids for 12 months. You just say, I need a year support award, here's what I want, and you file it with the probate court, right? So it doesn't take a lot of number crunching. It's just identify the property, list it in the petition, and file the petition with the probate court. Let's see. So what happens after you go and you file this petition? So as Gentry mentioned earlier, all of the forms are available at the county probate court, and you know they're not that difficult to fill out. They are also available online. And if you are, you know, a low or moderate income person living in Fulton and DeKalb County, you can try to make an appointment with the Probate Information Center, and they may have a volunteer attorney that can help you fill it out or you can fill it out yourself and without the need for an attorney. But once the petition is filed, the probate court is going to give notice to all beneficiaries, all heirs, and all creditors of the surviving spouse, or the deceased spouse and the parent's estate, okay? Because everyone is entitled to notice that you've asked for, you know, the house, you've asked for everything as your year support award. And the neat thing is if no objections are filed, the court will give you everything you asked for. So if I'm surviving spouse, my husband's passed away, and I go down to the courthouse, I get this petition, I fill it out, I list all of his property, including the house. I file it with the probate court. The probate court gives notice to everyone who's entitled to notice and says, you know, folks receiving notice, you have 30 days to file an objection. And nobody files an objection. But more likely than not, the judge is going to give me everything that's on my list without asking how much I would actually have needed for 12 months. So, you know, and it may actually, if you get that award, if you get an award of all of the assets, right, in the estate, you're getting those free of any debts from the surviving spouse, and it may negate the need for any further probate. If you get the assets, all the assets in the estate through your support award, then nothing is needed further on the probate front, okay? And that's why you ask for, you know, why a lot of people will just ask for everything, right, in the hope that no one will object. And the court will just give you everything without any further inquiry. You have a question?
We do. We have a couple questions.
Awesome.
This question is, when you get items from year support, i.e. home, can you sell it in that year if owned with others?
So you would get a partial interest in a property through your year support?
I suppose that's what is being, I think so.
So, I've never seen this before, where you're getting a partial interest as your year support. You know, if you receive, so a year support award, like the court gives you an order and says, here's your year support, here's the legal description of the property or the house that you're getting, and you record that in the land records, that's as good as a deed, right? And once you have a deed, you can do whatever, you own the property, right? And you can do whatever you want. So if you have a year support award that gives you a partial interest in a property, that's equivalent to a deed for that partial interest. But, you know, it's still co-owned, it's among people, it's still likely heirs property. And so, you know, it's the same thing you would have to go through to sell a piece of heirs property, right? You'll have to have agreement from everyone. You'll have to do, you know, all the different things you have to do. So I forgot to mention it, we should have. But we, in one of the earlier, I think the first webinar that we did goes into kind of title and heirs property and how to resolve it. So, so that is dealt with some, and how to sell heirs property is dealt with in that webinar. If y'all want to check it out, or you're welcome to email us. But most of the time, the year support is if you or your spouse, right, co-own the piece of property, or you own, or your spouse owned it by yourself, you can get title to the whole thing, right? So the partial interest is really only coming into play, I think, when you're basically the property was heirs property to begin with, right? Your husband or your wife or whatnot owned a piece of heirs property, right? And you use that year support award to get that piece of heirs property, it's still heirs property. But if the property wasn't heirs property to begin with, it was owned between spouses or parents, right? That's the way to get title to the entire property without having to go through further probate or, having to wrangle with, stepkids, adult kids, other people, and to get that property debt-free.
Okay, we've got another question. Is there a specific probate court form or specific format to use to file an objection?
Okay, so we haven't gotten to objections, but so the question was, is there a specific form to use to file an objection? I don't know that there is, but county probate courts are fairly lenient about kind of filings. I've seen people just send a letter to the judge saying, I object and this is why. Usually they'll take it down to probate court and the probate court clerk will notarize it, so it's under oath. You're testifying under oath essentially through a letter that you're objecting and this is why. So you can do it as a pleading, kind of in the same lawyer-like format as the petition for your support. But the way the probate courts work and the way in an attempt to make probate easy and accessible for folks, if it's something that they haven't already provided a form for, they're usually flexible in the format in which they will take something like an objection. And that's the same for an objection to a year support, an objection to a petition to probate a will, or a petition to be named an executor.
Okay. We have another question.
Okay.
If a decedent spouse owns a business and has debts related to that business, what is the surviving spouse's liability or responsibility in that regard?
Okay, so I'm going to put a pause on that one.
Okay.
We'll remember it later. Gentry's going to get into kind of, especially surviving spouses, who's responsible for what debts after a spouse passes. So I'm going to let her put a pause on that. But if that debt is something that's, that, I'm trying to think about how it would work with the business.
It depends on what kind of business it
Yes.
was.
So Gentry can explain what happens to the debt, right? But as far as a year's support petition, I'm not off the top of my head familiar with how any sort of business debt would be handled. But, if it's a debt of the deceased spouse, then the year's support petition is a way to try to get that property free of any and all debt, except the mortgage, because you can't get rid of a mortgage. So
I've got one more question. It's sort of a follow-up from the earlier question. What is the probate requirement for a will that includes property in a foreign country? If the decedent owned properties in a foreign country and in addition to his or her estate in assets in the U.S.
Okay, so I don't know the answer to that either. It depends. So, it's like with property in another, I can give the example of property in another state. If you pass in Georgia with a will and it deals with property in another state, going and getting title to that property once you become executor depends on the laws of the other state, right? But if usually in state to state, if the will is valid in Georgia and that will leaves property in another state to someone, you can, depending on the laws of the state, go to that state. So foreign property and things happening legally in foreign countries is going to be different based on foreign countries, and so you would need to talk to somebody who has experience in that specific country's laws. We don't ever see it, so.
Not very often. Sometimes you see it with like second homes, maybe in North Carolina, but I know North Carolina has weird, obviously it's not a foreign country, but North Carolina kind of has weird property transfers on death rules. But so to go state to state, it's typically an ancillary probate where you say this will's already been proved here, I'm the executor here, I'm going to refile the will for ancillary probate in another state just so we can have the authority here to transfer the property. So I would guess it's something similar, but I don't know.
Great, that's all the questions we have right now.
So just to tie the petition for your support, again, ask for the world, right? And if no objections are filed, right, the court, without further inquiry, the probate court is going to give you the world, right? If objections are filed, at that point, the probate court is going to schedule a hearing at which the probate judge will hear evidence on, what property is in the estate, how much that surviving spouse and or minor children needs for support and maintenance for 12 months, and then allocate what property is needed for that specific amount that the surviving spouse and children have come with evidence to show, and we'll allocate that property appropriately. It still may be possible to get, the house or further property as the year support award, even if there is an objection, but you're going to have to show up and go to a hearing. And so sometimes it's fairly easy to, get that probate petition filed, that petition for your support filed, right? And see if there's objections. And if there are objections at that point, it would probably be wise for the surviving spouse or the guardian of the minor children to seek legal assistance in that hearing, because that hearing will be very important. So just, again, it's not something a lot of people know about. It's a great way to protect surviving spouses and minor children, but it has to be filed within the first 2 years of death. So, you don't have to understand a lot of it, right? Hopefully you do now, but you do want to, as you're coming across folks who have spouses who've recently passed away, or children, minor children with parents that have recently passed away, it is a good idea to direct them to the probate court to see what may be possible, or to a lawyer or to the center to see what may be possible to obtain through that. And so if we don't have any further questions on that, we'll get Gentry. We'll close us out with debt issues.
So what happens with your debt when you pass away? Your debt generally is not inherited. So that doesn't mean it disappears. It just means that your heirs don't become liable for your debt. Your estate, your debts becomes debts of your estate. And so whoever's been appointed administrator or executor is responsible for ensuring that those debts are paid. In order to pay them, your assets, which would typically go to an heir, which may be your home or maybe cash, can be accessed, must be accessed to pay those debts. But that doesn't mean that the family members are personally responsible for paying them. If there's not enough money and there's not a home or other assets in the estate to pay that debt, then that debt just goes unpaid. Now, if you may inherit debt if you actually jointly own that. So you become responsible for a deceased relative's debt if you are a joint account holder, a co-signer, or a joint debtor. If you're just an authorized user on a credit card, you're generally not obligated to pay that debt, but you should stop using that credit card immediately. And then there's a little caveat in that surviving spouses in community property states, so that's Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, Wisconsin, you may be liable for your deceased spouse's debts. And I'm not positive, but it might even be if you've ever lived in one of those states with that spouse who has since passed away. Other family members have no obligation to pay your debts. Creditors cannot report deceased relatives' debts on family members' credit reports if those family members have no legal responsibility for them. Now, with a mortgage, when a deceased relative dies before paying off a mortgage, the mortgage company still has a right to repayment. That's because the security lien attaches to the property itself, and it must be repaid regardless of who owns the property. You are not required to keep the mortgage if you inherit the home. You can either refinance it or pay it off in full, or if you're not interested in it at all, you can just sell the property, let the sale pay off the mortgage, and then take what's left, if anything. The house, since the house or land is serving as security for the mortgage, it can still be sold at foreclosure if payments aren't received. So if you know that there's a mortgage, well, even if you don't know, but mortgage payments need to be, they should still be paid after the decedent dies, because the bank can still come and foreclose upon it. This is especially important if you're living in the home and intend to intend to stay. Oftentimes we see debt collectors badgering, harassing, and intimidating relatives and trying to exploit people who think that maybe they are supposed to pay these debts. So be wary of this. Let people you work with know to be wary of this. We often see also where people are checking obituaries and all the probate filings, and we'll just start contacting relatives posing as debt collectors. So be on the lookout. When somebody passes away with debts, the things you should do immediately. Number one, stop using credit cards where you're just an authorized signer or a card holder. So maybe your spouse actually had the credit account, but you had a card with your name. You should stop using that. You should also contact the holders of your deceased relatives' loans and credit card accounts and other debts to let them know that they've passed. This will close the account and let the creditor know that whatever's still owed will be handled through the probate process. It's also a good idea to notify the credit reporting agencies. Those are the three, TransUnion, Experian, and Equifax, and let them know that this person is passed so that they can be on the lookout for any activity. You may also want to notify the IRS that they have passed away so that the IRS is on alert if somebody tries to file on their behalf. If you are contacted by a debt collector, you should direct them to the executor or the administrator because they are the person responsible for ensuring that debts are paid, not just any family member. Debt collectors can contact the surviving spouse, guardian, parent if the debtor was a minor, and executor or administrator unless they're instructed in writing not to do so. They are not permitted to represent that anybody other than the deceased person is obligated to pay the debt unless, of course, it's a joint debtor situation. Debt collectors are prohibited from discussing debts with the debtor's children, siblings, and other family members, but they may be those family members may be contacted to get contact information for surviving spouses or the executors and administrators. Relatives who are being harassed by debt collectors can send cease and desist letters prohibiting further contact or file complaints with the Federal Trade Commission. And then remind me again of what the question was about debt, the one about debt that we put a pause on.
Business.
Business.
The business debt, yes. And we have another question as well.
Okay, so
it says, if decedent spouse owns a business and has debts related to that business, what is the surviving spouse's liability or responsibility in that regard?
So the question was, if I could repeat it, if the decedent had a business that had debts, what is the surviving spouse's obligation to pay that debt? There's not an obligation. That debt becomes a debt of the estate. And then even then, it depends on what type of business it was, because if it was, I'm not an expert in businesses and unincorporated businesses, but what type of business determines who actually owns it. So if it's just if it's a partnership, then maybe the partners are still obligated for those. So I'd say it depends on what type of business it actually is. But if it's a personal, if the deceased person has a personal liability to pay that debt, then that debt becomes the debt of the estate. Hopefully that makes sense.
So no surviving spouses aren't responsible for it.
Okay, one more question.
That was the question.
If a parent did a Parent Plus loan, so I believe this is a student loan situation, a parent did a Parent Plus loan, and then passes away, will the house that they leave to a child be obligated to pay that loan off? Well, so I guess would the house be, would the creditor have access to the house as an asset to pay off the loan?
So the question is for is it child plus parent plus loan. So basically the parent is co-signing onto some sort of loan, whether for college education. Some parents will co-sign, or even children will co-sign for parents on house mortgages and the like, right? So the parent could be, depending on the terms of the loan agreement, right? Because they can differ. The parent could be liable for that debt independent if the child passes and the parent survives, could be liable for that debt. And the same thing with if the parent passes, the child is still obligated for that debt, usually. And usually you want to check the terms of the agreement that the parent and child signed, and may have some provisions as to what happens if, especially if the parent passes. If if it's something that had been paid up until the death of the parent or child, that, could, depending on the agreement, could become a debt of the deceased parent or child's estate. That would have to be repaid, right? And in order to repay debts, in some instances, it necessitates the sale of property, right? If it was a lien, if it was unpaid before the person passed, right, and it's a lien on the property, then that lien could be subject to any inheritance, right? It just kind of depends on how the agreement works, right? And so you should always go back and when someone passes and check those types of agreements and make sure you're trying to keep them current, and make sure if that's a responsibility if the responsibility ends for the parent or the child upon death, and thus their estate responsibility disappears, or if it's something that the survivor is still going to be 100% liable for, regardless of what happened to the co-signer.
So I think a parent plus loan is a loan where only the parent is on the loan.
So I'm not familiar with that specific type of loan, so I would look at the loan agreement because it should set out in the loan agreement what happens.
Great. All right, let's see if we have any more questions. I don't see any further questions.
Great. Well, apologies for going a little bit over, but I hope it was helpful, the overage parts, and want to respect everyone's time. So we thank you for participating with us today. Again, I'm Joanne Johnston, a Gentry Mander. Welcome to give us any calls with any follow-up questions or emails, and we'll be happy to answer any questions. So thanks for participating, and look for more of these webinars from the Generational Poverty Law Project in 2019.